Hello, my name is Travis Hall. I am the program manager for court-ordered benefits here at the Office of Personnel Management. I have with me today two of our paralegal specialists who also work in court-ordered benefits. They are part of our team. I have to my left Shania Hill, who is a paralegal specialist, and Denise Hicks, who is one of our senior paralegal specialists. And if I can't answer your questions, I'm sure these ladies will be happy to help out. Today, I want to talk to you, we're here to talk to you regarding court-ordered benefits. Now, everyone is pretty much familiar with the benefits that OPM pays out to our annuitants based on their age, their years of service, those service-based benefits. However, there is another part that we play in the grand scheme of things, and that is paying court-ordered benefits. Those are, just as it states, benefits that have been awarded or ordered by the courts. And so they are generally awarded to former spouses. And today, what we're going to talk about, our agenda is former spouse benefits under the Civil Service Retirement System, or CSRS, Federal Employees Retirement System, or FERS, Federal Employees Health Benefits, FEHB, Federal Employees Group Life Insurance, or FEGLI, and the other OPM insurance plans such as FEDVIP, FLTCP, and FSA. Some of these benefits are payable with court orders, and some of them are not, and we'll discuss them more as we get to them. Just to give you a little idea about the background, OPM published in 1992 some new regulations regarding court orders, and they are found in the CFR, or Code of Federal Regulations, Part 838. That is kind of our Bible in Cobb. Anything that we need to know, we go back to Part 838 of the CFR. And a little bit later, we published a handbook for attorneys on court-ordered benefits, health benefits, and life insurance. And that tends to be sort of the Bible for our customers. A lot of times people will call us or write into us asking us to pre-approve orders, or to ask us, well, if I put in this language, will this work or will that work? And what we cannot tell them what will work or what won't, but what we can do is point them to that handbook. And the handbook gives all of the necessary language. It gives all the proper citations. It gives everything that they need to submit a successful court order, one that will be approved. One thing to note is that OPM's role is ministerial. We don't draft court orders. We don't do anything except administer what the court will order us to do, as long as it meets the regulations. The role of, and we act as sort of the mediator. The mediator actually rather belongs to the state courts. They're the ones who hash out what's fair, who gets what. We don't get into that. A lot of our clients or our customers will call us saying, well, it's not fair. I should get X amount of dollars, or I should get this, or I should get that. That's not for us to determine. We leave that up to the state courts, and we are simply ministerial. There are a number of benefits that are payable. A court order may independently affect any of three types of retirement benefits paid by OPM. Those include, as you'll see on the slides, employee annuity payments, refunds of employee contributions, and survivor annuities. The bulk of our work in court order benefits comes from the annuity payments and the survivor annuities. More recently and less frequently do we see the refunds of employee contributions, but all of those things may be affected by a court order. What we receive in our office are court orders acceptable for processing. And what that simply means is and you'll see on the slide all of this in more detail, but what it means simply is a court order that meets all of the regulations, makes all of the proper citations. Everything is there for the court order benefits branch staff to do what we need to do, to apportion that benefit, to divide the benefit between the former spouse and the federal retiree. To effect an employee annuity or refund, the retirement contribution or a refund of contributions, a court order must, first of all, specify the retirement systems. It can't just ambiguously say the retirement system or the retirement plan. It has to identify CSRS or FERS benefit as according to Title V CFR Part 838. And it has to use language that is acceptable under the plan. I will let you know that a lot of things that you hear today will be repeated, and it's by design. They'll be repeated for effect and for you to really drive certain parts home. And so what I will say here, to repeat myself, is that all that language is in the handbook for attorneys. And of course, there is a link that we'll give you later on, which will give you the link to the electronic copy of that, and anyone can access that. The order must also expressly state that the former spouse is entitled to a portion of the employee annuity or the refund. Again, the language has to be specific. It must expressly direct OPM to pay the former spouse directly or be silent on the payer. It cannot say that the annuitant is to pay the former spouse. It must direct OPM to pay. Or, as I've just stated, it has to be silent. If it's silent on who pays, then we will assume that it is OPM that pays the benefit. But if it directs the annuitant to pay his former spouse or her former spouse, then it's out of our hands. Court order acceptable for processing also provides sufficient instructions and information for OPM to compute the amount of the former spouse's share of the employee's annuity or refund. By compute, we mean it's not always cookie cutter. It's not always cut and dry. It's not always 50% or 40%. Sometimes it is something that is called a pro rata share, and that's based on the years of marriage, as a fraction which is based on the years of marriage divided into the total length of service. And sometimes these can get rather dicey, I'll say, for lack of a better term. But it must be specific on how our staff is to compute that benefit. In the case of a portion of the employee annuity, or an apportionment as we call it, it must specify the type of annuity for application of the formula, the percentage or the fraction. It must state what type of annuity that person is going to get, whether it's going to be the net annuity, the gross annuity, or self-only annuity. And those are important because we need to know which number, once the legal administrative specialist in our pending branches, once they come up with the numerical part of the benefit, we need to know which benefit or which number to apply the formula to. Now, to award a former spouse survivor annuity, a court order, now what we've talked about prior to now is the apportionment. For the survivor annuity, a court order has to also specify the retirement system, FERS or CSRS. It also has to expressly state that the former spouse is awarded a former spouse survivor annuity, or direct the employee or annuitant to elect or provide that former spouse survivor annuity to them. That is not a benefit that they just automatically get. That is something that has to be awarded. It must state that explicitly in the order. Again, it must provide specific instructions for us to compute that the former spouse survivor annuity, and it must be, and this is particularly key in the survivor benefit area, it must be issued prior to the date of retirement or the date of death, whichever is earlier. You know, we can't get, after the gentleman or the lady who was the federal employee or federal retiree dies, we can't get a new order saying pay a benefit, pay a survivor benefit. It has to happen prior to the retirement or the death, whichever is earlier. And I will, you know, I would caution you to make sure you let the employees know that, because we have a lot of former spouses that, you know, come to us thinking that they were awarded a survivor benefit when actually they weren't. They may, the gentleman or the federal retiree has retired. They might have gotten divorced 5, 10 years before the retirement, and there was no survivor benefit awarded. A couple years later, the retiree dies, and all of a sudden, the money stops. And they want to know, why is it stopping? Well, you weren't awarded a survivor benefit. So that's very important for them to know, that if they want that that benefit to continue after death, then it must be already in place.
Can I address something?
Certainly.
The second bullet point on the slide where it says it must be awarded in the first order, dividing marital property of the retiree and the former spouse. We get a lot of court orders that come in for post-retirement divorces. And a lot of times these people will have a divorce decree, sometimes a property or marital settlement agreement, and then a court order dividing the federal benefit. If in that divorce decree or if the divorce decree and the settlement agreement are done at the same time, say they're both done on June 1st, and then the court order dividing the federal retirement benefit comes in on June 2nd. If there is no survivor benefit awarded to that former spouse and that divorce decree and marital settlement agreement that were done on June 1st, and then the court order dividing the federal benefit on June 2nd awards a survivor benefit, we cannot honor it. So anytime you have a marital settlement agreement or divorce decree in which property are divided, the survivor benefit should be awarded in the first agreement dividing property. If it comes later in a court order acceptable for processing or any other qualifying court order that we may see dividing the federal retirement benefit, we cannot honor that survivor benefit. It must be awarded in the first place in that divorce decree or marital settlement agreement where you're dividing the property that was accumulated during the marriage.
That is a very, very important, and it's been our experience that a lot of times benefits officers will call us while the employee is still going through the divorce, while they're still drafting the papers. So this is a key point that you would want to let them know, that it must be in that first order, dividing property. Thanks, Shania. A court order related to a divorce or legal separation or an annulment can divide a civil service retirement system or FERS annuity. It also can divide a refund of the civil service retirement system or FERS employee retirement contributions. It also may provide a survivor annuity payable upon the death of the employee or retirees, except in the case of a legal separation. I'm going to ask if one of the two ladies would give you some more insight on those.
The only reason that we say except in the case of legal separation is because if you're legally separated, you're not technically divorced. So under our terms, you would still be considered the current spouse, and then you would be afforded all the same benefits of a current spouse, including the ability to, including the right to have to sign a spousal consent form if that current spouse decides that they don't want to provide a survivor benefit. So you would have to, as a legally separated current spouse, you would have to voluntarily sign away your right to receive a survivor benefit. Other than that, a court order can't legally take it away until you're actually divorced.
And yes, that's fine. And
Okay.
actually, the next two slides are yours as well.
The other things that a court order related to divorce, legal separation, or annulment can do, they can allow a former spouse to continue coverage under the FEHB program or the Federal Employee Health Benefits Program. If they get a divorce and the person is still a federal employee, the former spouse would continue initially under FEHB with the temporary continuation of coverage program. And then after a court order is submitted to the court order benefits branch and they receive an approval letter from us, they can go under spouse equity, which affords them like a 1% discount? Is it 1 or 2% discount on the FEHB premiums?
I think so, but once they receive a approval letter from us and they're still, the employee is still working, they have to take it to the agency, and the agency will process that request for health benefits. Once they're retired and we send out the letter, we have someone in our office that handles the health benefits for former spouses. So when they send it back, that person will get in contact with them to discuss their health benefits. If they have any questions, let them know how much the benefit is in their area, because you get a booklet that lets you pick out what health benefits that you have available for you in your area.
You know, that's really, really important, because ever so often we do get calls from people who are, or former spouses or people who are currently employed and wanting our staff to handle those health benefits questions or those health benefits enrollments. And it really must be driven home that if the person is, if the employee is still employed, then their agency has to process the former spouse's health benefits.
And if they're retired,
Then
they
it's
all
us.
come through OPM.
Yes.
The other thing that a court order can do is require an employee or an annuitant to continue to enroll in a family plan under the under FEHB so that they can provide health benefits for their children. It can also require an employee or retiree to assign all or a portion of their life insurance benefits over to a former spouse or a child of the marriage. It can require an employee or a retiree to designate the former spouse or one of their children as a beneficiary under FEGLI. And in addition, a court order may also affect retirement benefits, in that retirement benefits may be garnished for alimony, which is sometimes called spousal support, child support, or they can be ordered to pay monetary judgments awarded in child abuse cases. Those are rare, but we do occasionally see where a retiree has had his annuity garnished to pay a monetary judgment that was awarded in a child abuse case in which they were involved.
Now, those are the things that a court order can do.
Mm-hmm.
There are a few things that a court order cannot do regarding the benefit plans that are administered by OPM. Particularly those, the FEDVIP programs, the dental and vision insurance programs that are administered by OPM. Court orders cannot make a former spouse eligible for those particular dental and vision plans. It cannot require the agency or retirement system to enroll an employee or an annuitant in the FEDVIP plan to cover the children. So really, in short, FEDVIP plans are not part of the court order. They're not currently anything that we will administer in court orders at all. The other thing, other benefit that, one other benefit that OPM administers is the long-term care benefit. And court orders cannot award that to a former spouse. To be eligible for the long-term care benefit, you have to be a relative. And once you are divorced, you are no longer a relative. That's kind of a hard pill to swallow for some of our customers, but that is something that we have to, get across to them, that the reality that they are no longer a relative, and therefore they are not entitled to that particular benefit.
One of the questions that we often get from attorneys who are seeking advice from us is whether or not the same rules apply to private sector employee pensions as they do to federal pensions. And the overall answer is no. The rules governing federal employees' retirement benefits are handled under, or the regulations are found under Title V of the U.S. Code, Part 838. Court orders that affect private pensions are governed by ERISA, or the Employee Retirement Income Security Act. CSRS and FERS federal pensions are exempt from being divided under ERISA. So we don't do ERISA orders at all.
We don't touch those at all.
We don't touch orders with ERISA language at all. Court orders that have an effect on FEHB, you can find those regulations under Part 890 of Title V of the Code of Federal Regulations. You will find the rules that govern the Federal Employees Group life insurance and court orders under Part 870 under Title V. A lot of times the court orders that are used to divide private pensions are called Qualified Domestic Relations Orders, or quadros for short. Most quadros are not valid under FERS or CSRS, but a court order dividing a federal retirement benefit that is labeled a quadro or qualified domestic relations orders can sometimes be acceptable under CSRS and FERS if it meets the guidelines of Title V, Part 838 of the Code of Federal Regulations, i.e. it has to use the language and meet those rules and regulations before it can be applied to a CSRS or FERS federal benefit. If it doesn't meet those rules and it uses language that is totally from ERISA, court order benefits will not accept that order. So even if it's labeled a qualified domestic relations order, it still has to meet the regulations of Title V, Part 838 before it will be accepted by OPM.
Yeah, so we can't just, that's another thing to kind of put a pin in. Just because it says quadro doesn't automatically make it not applicable here. It just has to have the right language. Very often, I'm sure many of you get calls from attorneys just like we do, wanting to know where they can find the proper citations or the rules that apply to the federal benefits. And on the slides that you'll see that CSRS benefits in that Code of Federal Regulations, Part 838, are in sections 8341, 8342, 8345, 8346 of those of the United States Code, pardon me. FERS benefits, 8401, 8445, 8467, 8470, also part of the U.S. Code. The FERS and CSRS benefits, as we've been talking about jointly, Part 838 of the CFR. Former spouse benefits, and as you can see, you have all those there. They are, this gives the citation. So this would be a nice sheet to kind of keep up close by if one of the attorneys, or sometimes even the employees or annuitants will be drafting their own, and they will want to know the citation. These are the citations.
Also,
yes.
Mm-hmm. Also, in regards to life insurance, we do not make determinations on life insurance.
Turn the microphone
The life
toward.
insurance we send to our office in Boyers so that they can keep it on file when the employee or retiree dies. We give those court orders to O'Fagley's office for them to make the determination on the life insurance.
Absolutely.
And prior to, after a person retires and the Office of Personnel Management has their records and their retirement information on file, Court-ordered benefits doesn't keep any information on who the beneficiaries are for that person's retirement benefits, whether it be the life insurance or any annuity that's payable after the death of that person. That information is not kept in court-ordered benefits or in anywhere in Claims 1. If somebody wants to know whether or not a person is abiding by a court order that forces them to designate a certain person as a beneficiary for the life insurance, they're going to have to call our Boyers, Pennsylvania office, our Retirement Operations Center, in order to obtain that information, because it's not anything that we maintain in court-ordered benefits.
As we referred to before, the handbook, all of these provisions, all of these regulations, along with the retirement health insurance and life insurance regulations, they are contained in the document RI 38-116, which has an extremely long name, but we just call it the Handbook for Attorneys. And you will see the website, the link at the bottom of the screen. But that, again, that is really the Bible for court orders, that particularly from your side. That is where you can find pretty much all of your answers.
And like we said before, it contains all the regulations that govern court order benefits and the way that they can affect retirees' annuities. But it also contains sample language for attorneys to be able to use to get exactly the result that they want when a person retires and a court order has to be applied to a retiree's benefit. I believe the sample language is provided in the handbook because OPM doesn't offer any assistance on drafting court orders that are acceptable for processing. Everything must come from the attorney and be validated and signed by a judge in the state from which it's administered. OPM will not help you draft a court order that's acceptable for processing. That's up to the attorney and up to the state to determine what's acceptable.
Only thing that we can do is answer any specific questions that you have regarding your court order and writing it up. If you have certain questions, then if we are able to answer them, we can, but we cannot pre-approve or help you draft an order.
Okay.
Actually, I think we got an online question related to what we were just discussing. And that question is, can an employee MSA, and I believe that's marital settlement agreement, be provided to and reviewed by OPM prior to the federal employee retirement to obtain opinion that the divorce agreement meets the requirements of OPM to correctly calculate a benefit to a former spouse? And then the second question is, who and where should the marital settlement agreement be sent by the employee? At this time, we are not reviewing marital settlement agreements, or like I said, any documents really related to the divorce, to determine whether or not it is applied correctly or it meets the regulations. The only thing that you can do is submit it ahead of time, like most employees do. They will submit the divorce decree, the marital settlement agreement, and sometimes an order dividing the retirement benefit, and we'll review it while they're still an employee to let them know how that formula will be applied at the time of retirement. But we can't provide any exact figures on how much that dollar amount will be or anything like that, because OPM doesn't have your employee history with us until the time that you retire. So we can't provide direct information on basically how much will my former spouse get, and we get that question a lot. We just don't have the information to do it, but we can tell you how your court order will be applied to your retirement benefit at retirement. We just can't give actual numbers.
If this is a draft of your marital settlement agreement, the only other thing that you can do is look in the handbook. If you're awarded a benefit based on a formula, there is a model paragraph that you can use to show exactly a sample of how it will be divided. So I would refer the person to look in the handbook and look to see what they're trying to divide, how they're trying to divide it, and find that model paragraph. And if it's closely related to what they have in that order, then you know you're on the right track.
We also have a second question from online that relates to something that we covered a little bit earlier in the presentation, and that's federal employee health benefits. And the question reads, I'm getting divorced, and once I'm divorced, I want to pick up health benefits coverage for my daughter and myself as a qualifying life change. It looks like presently the husband or the former spouse carries family coverage for everyone. But this person is saying that they were informed by the health insurance plan that he has to submit something in writing to OPM, and it has to be approved by OPM before she can pick up health benefits for herself and for her daughter. I guess this question goes two ways. If this person is still an employee, she would be immediately eligible for temporary continuation of coverage by submitting the divorce decree and the health benefits form to the employing agency. If this person is a retiree, there is some truth to what the health benefits plan is saying. The divorce decree, supporting documents, and any order dividing the benefit would have to be sent to court-ordered benefits at OPM and approved before she would actually be eligible to receive health benefits through the current health plan. And she would only be entitled to those benefits if she was awarded an apportionment and or survivor benefit.
If she wasn't awarded a portion of the benefit, then the only thing that the former spouse is entitled to is the temporary continuation of coverage, which only covers for 3 years. And you're eligible, well, you're on the family plan for the 30 days after the event, the divorce. After that, you will have to get health insurance, either TCC or send the documentation to court order. And if we approve it, then you can apply for spouse equity.
Okay, thank you. To continue a little bit about where attorneys might find the rules that apply to federal benefits, also, as we've mentioned before, garnishments are affected by court orders, and those can be found in Part 581 and 582 of the Code of Federal Regulations, 5 CFR. Two other areas, the Thrift Savings Plan and the military retirement pay, those need to be mentioned because they are, a lot of times we will get orders citing those two benefits, TSP or military retired pay, but those are not administered by OPM at all. The TSP is administered by the Thrift Board, and that person would go to www.tsp.gov to get some more information regarding that, and they would go to dfast.mil in order to get more information regarding the military retired pay. So those are not administered by OPM at all. The question is asked, when can a court require withholdings from the Civil Service Retirement System or the FERS benefits? It can order an apportionment to divide the benefit in connection with a divorce, legal separation, or an annulment of a marriage. The court order must expressly, as we've stated before, direct OPM to pay a portion of that monthly benefit to the former spouse. It must tell us to pay it, and then we will do so. When it states that the former spouse's share, when it states it as a fixed amount, a percentage, or a fraction, or by a formula, then we will do so. And as these ladies can attest, we get a wide variety of designations or ways that the benefit can be divided, but these are the basics. A fixed amount, $200 a month, a percentage, 50, 30%, et cetera, or a fraction, half, or some formula.
And when we say that we need a formula whose value is readily apparent on the face of the order. That means that they give us the exact formula that they want us to use in the court order. Or we can pull some information that we should have in OPM's files. And I mean, that will be very basic information. Pay history, salary rates, those type of things are readily available in OPM's files. Things that are not readily available in OPM's files sometimes are the date that you divorced the person. We've had court orders come in that says, reduce the amount of the benefit you determined by half the sale of the, half the value of the house that we sold in January. Well, we don't know what your house sold for in January. So the court orders need to be really specific, and keep in mind that we can only pull limited information from the retiree's actual file. So any information that you want us to have to apply to that court ordered formula really should be in the court order itself. Don't assume that OPM has all of the information, because sometimes we don't.
Right?
I'm good. That's it.
The next one's yours.
Okay, the apportionment that we talked about earlier, well, I like to think of the retirement benefit as divided basically into two parts. There's a part that's payable to the former spouse while the retiree is alive, and that's what we call the apportionment. And then there's the part of the benefit that is sometimes payable upon the death of the retiree, which is the survivor benefit. The apportionment usually ends, or is designated to end, upon the death of the retiree. We can't take any orders that award what we consider to be a lifetime benefit, which will basically tell OPM that the former spouse's portion of the retirement benefit isn't affected by the death of the retiree. It's affected by the death of the retiree by law. Once the retiree dies, that monthly benefit that you were receiving, it will end. The only way you can continue to receive a benefit from that retiree's annuity is if that court order, is if there was a court order that awarded you a survivor benefit, or that retiree elected to voluntarily provide you as a former spouse with a survivor benefit. The other way that court orders can affect withholding or CSRS and FERS benefits is the contributions. Anytime a employee, because you would still be an employee if you were getting a refund of, a separated employee, if you were getting a refund of contributions, that court order can say, don't pay that refund to that employee if they try to get a refund of contributions, or it may tell court order benefits how to divide the contributions if that separated employee ever applies for a refund. So the court order sometimes provides that we pay all or just a small a portion of the contributions to a former spouse if a separated employee decides to apply for a refund. Like I said before, court order may also block payment of a refund, especially if the court order awards the former spouse a survivor benefit, because if the employee takes the contributions, then they're not eligible for retirement, which in turn negates the survivor benefit that was awarded to the former spouse. So a lot of times the court order will block a refund, or not allow a separated employee to get a refund of contributions, because it will block the future benefit of the former spouse. Where are we at? I'm applying for benefits. We'll talk about how a former spouse can go about applying for benefits a little bit later in the presentation. But the court order can provide, like we said, survivor benefits to the former spouse. And that is a monthly benefit that is payable after the death of an employee. Like I said before, a retiring employee may also voluntarily elect to have his annuity reduced fully or partially to provide a former spouse a survivor annuity. But if that annuitant is currently married, if at retirement and they want to provide a survivor benefit for a former spouse, the current spouse has to sign a spousal consent form, which shows that they agree to receive a lesser survivor benefit, so that this annuitant can also provide a survivor benefit for their former spouse.
It might be also significant to note that the apportionment, that monthly benefit, is payable at the same time as the annuitant receives his or her monthly benefit. So that is generally the first business day of the month. which most often falls on the first.
Okay. So survivor benefits can also sometimes get a little tricky. A court order cannot award a survivor benefit unless the marriage lasted for at least 9 months. And I do believe under FERS, they also have to have at least 18 months of service.
Yes.
Yes.
Yeah, so under FERS, the Federal Employee Retirement System, you have to be married at least 9 months, and that person must also have at least 18 months of service. A former spouse can lose eligibility for survivor benefit if that former spouse gets remarried before age 55, and the only thing that negates that is if the employee and the former spouse were married for at least 30 years. So if they were married for at least 30 years, it wouldn't matter how old she was if she got remarried because the marriage lasted 30 years. If she remarries before age 55 and she was not married to that employee or annuitant for 30 years, then she is not eligible to receive the survivor benefit even if the court awards it.
We have a couple of questions while you're right there.
Okay.
How about I read the questions
Sure.
and you ladies feel the answers?
And then we'll take one from the audience. We'll read this one and then we'll take yours.
Okay, great. This person has 2 questions. First, do you notify the employee or spouse if the agreement does not meet OPM standards?
Yes. We will notify the employee and or former spouse either way. If the court order is acceptable, you will be notified that it is acceptable for processing and the formula that will be applied to your retirement benefit when you retire. If it is not acceptable, we usually will provide you the portion of the regulations under Title V, 838 that the court order did not meet in order to divide the benefit.
Question 2 from this person says, when calculating what the former spouse is entitled to, which sick leave balance of the employee is used in the calculation?
That depends on the court order.
Yes, if the court order is based on at the time of retirement, we're going to use the sick leave at the time of retirement.
Okay.
If it's based on if a date other than retirement, we don't use the sick leave.
Unless the court order specifically gives us a sick leave amount to use in the calculation. So if the calculation is based on a date prior to retirement, and the court order wants us to use sick leave in that calculation, they have to give us the specific sick leave amount that they want us to use. Otherwise, no sick leave will be used in that calculation.
Okay.
Audience question.
A question on the current slide where it says if the former spouse who marries before age 55, the scenario I have is they were married for 18 years. She remarried prior to turning 55. The employee would like to know what documentation would he have to submit with his retirement application to prove that his spouse is no longer eligible to receive that spousal annuity or the former spouse annuity.
They should submit a marriage certificate. I'm sorry. They should submit a marriage certificate. If they don't have access to that marriage certificate, we will contact the former spouse and let her know that we have received information of a remarriage and ask that former spouse to send us a marriage certificate. But until we receive that, it's nothing that we can do as far as not giving that survivor benefit.
Okay, a follow-up question with that. As I understand it, that spouse has relocated from the address that was provided in the divorce decree and everything else. So would we be responsible for providing you with her new contact information via memo in the application?
If you have that information, and if you don't, we send it to the old address, and sometimes we'll get it back with the new address on the envelope, and we'll forward that letter to the new address.
Okay, thank you.
But we are putting systems in place now that will allow our paralegal specialists to research and find those persons that are missing a little bit easier. Yeah, sir.
Since the divorce decree is not a document that's stored in the EOPF, whose responsibility is it to forward the divorce decree to court order benefits section? Is it the employee are the attorneys of the spouse and the employee?
It's up to the former spouse to submit application for her court-awarded benefits, her or the attorney. But at the time of retirement, that question about is a former spouse awarded a survivor, then you put a copy of that divorce decree along with the application. But the former spouse is the one that's supposed to submit application for her court-awarded benefit or his benefits.
Okay. You have another question here. It says, when determining a former spouse's benefit, actually, that is the same question.
Okay.
We have this one. It says, does the court-ordered benefits branch always send a notice stating whether the court order is acceptable for processing and when it is not? I believe we've already addressed that. Do you ever send your determination to agencies upon request so that we can proceed or not proceed with the enrollment of FEHB under spouse equity provisions?
I would say that's pretty rare, right?
Right.
Yeah.
What the former spouse is supposed to do if the employee is still active is take a copy of the letter that we send with them when they're applying for the health benefits so that the agency can have a copy of that letter on file.
Here's another question. So if you receive a court order from the federal employee and another one from the ex-spouse, will you send your determination as to whether there is a COAP to both parties? COAP meaning court order acceptable for processing.
Does that mean the employee is sending us one thing and the former spouse is sending us something different?
I believe the question is if they both send the order, the same order.
Okay,
Would we reply to them both?
yes. Once that court order is approved, or not approved, as the case may be, all the parties are usually notified. Like, we will notify, well, if the attorney sends it in, we notify the attorney. If the former spouse or the employee or annuitant sends it in, we will notify them.
Here's a very interesting question. Is it true that you have access to a national database to confirm divorces and court orders? E.g., a retiree cannot try to hide if there's a court order on file.
I wish we were that sophisticated. That answer is a resounding no. We're pretty much still relying on the honesty system. Tell us if you're divorced, tell us if your former spouse is due a benefit, and let us see the court order. But we don't have access to any sort of database or anything.
And the last question from this person, it says, what rough time frames can we tell the parties that they can expect to wait for a determination from your branch?
For employee orders, 90 days.
Yes, we have a tremendous volume of court orders that come into our office. This is not to make any excuses, but if you think about how extremely large the federal government is and how many people get divorced, we literally have a team of 34 people who are in one way or another processing those court orders, and some of those are customer service specialists, so they're not actually processing the orders. They're the ones taking the phone calls and opening the mail and things of that nature. So, yeah, the rough estimate is about 90 days. We're working on shortening that time frame, but that's what you can expect.
We got an audience question.
A follow-up, because that was my actual question, but given the answer. Is there a way that we can follow up if the former spouse does not receive a response within, well, after that 90-day time frame has elapsed?
Certainly. You can feel free to call our office, and we will get back to you. I see For those of you who might be viewing us via the web, I was just looking at her face and reacting. Again, our response may not be immediate, but we will get back with you
Okay.
if you follow up with our office.
Okay. And which information or what information should we provide? The former spouse's name, social, that kind of information, or the employee's information?
I would have both, just
Okay.
to be on the safe side, just the name and social of both parties to be on the safe side.
Okay, thank you.
All right, let's move a little further in our slides, and we do have a couple more questions for a little bit later.
Okay. So this is kind of like when benefits are payable upon death. So if an employee dies, a court-ordered survivor benefit is only payable to the former spouse if the employee completed at least 18 months of service, and they die while covered under CSRS or FERS. If the employee has been divorced at any time prior to his death, we will need certified copies of the divorce decree and supporting documents, along with the application from the former spouse for benefits. Under CSRS, if an employee dies, a survivor annuity is payable, but under FERS, they're kind of like two benefits. Survivor annuity is payable under FERS if the person has at least 10 years of creditable service, but FERS employees, survivors also receive what's called the basic employee death benefit. And that basic employee death benefit, I believe, is a lump sum that they pay out, a one-time lump sum, but it may, all of it or a portion of it may be payable to the former spouse, but only if it's specified by the court order. So in short, in a court-ordered survivor annuity under FERS doesn't necessarily entitle you, the former spouse, to receive a portion of the basic employee death benefit. That has to be something that's expressly stated in the court order. If a separated former employee dies before they retire under CSRS, no survivor annuity is payable to a former spouse, even if the court orders it. Under FERS, in limited circumstances, a survivor annuity may be payable if a separated employee dies before retirement, and that's if they've had the 10 years of service. That person may be entitled to all or a portion of the survivor benefit, and like I said, the basic employee death benefit, but only if that was expressly awarded in the court order.
There are limitations to how much a survivor benefit can be awarded, and they differ in CSRS and FERS. Under the CSRS system, the maximum amount of the survivor benefit is 55%, and that is awarded to both, if there's a current spouse and a former spouse, it cannot equal any more than 55%. And then under FERS, the maximum possible annuity is 50%. And again, that it could be 1% and 49%, 25 and 25, however they want to split it up, but it cannot exceed 50%. All right, another question, how are current spouses' survivor benefits affected by a court order awarding benefits to a former spouse? Another way that an employee who's in good health can make an insurable interest survivor election at the time of retirement to provide a current spouse with additional survivor benefits, and that is only if the current spouse has consented to an election not to provide a regular current spouse survivor annuity. That's pretty standard. Before we go on, let's look at a couple of these other questions. All right. This person says we didn't answer their question totally. Says, I am a federal employee with over 30 years, and I am eligible to apply for federal health benefits once I am divorced because it is a qualifying life change. The person's husband is already retired.
So like we said,
So she says, I do not need to apply for TCC. She just wants to know if she can complete the SF 2809 and pick up the coverage for her daughter and herself after she is divorced.
Not without an approval from us,
She's a
right?
federal employee, correct?
Yes, she's an employee with over 30 years of service.
She
And
can do
she's-
that. She should be able to do that if she's still working.
Yes, she wouldn't need,
You wouldn't even need anything she wouldn't need anything from court-ordered benefits. If she's still working and the husband is retired and they're getting a divorce, she should be able to roll over her insurance to her own family plan with a qualifying life event. That wouldn't have anything to do with court-ordered benefits at all because she's still a federal employee. Now, if she were not a federal employee, then it would come through court-ordered benefits, and she would need a decision from us before the health benefits plan would enroll her in a family plan under her own right due to the divorce. But with her being a federal employee, there's no need for COB to interfere with that. She could roll that over as a qualifying life event.
okay. Here's one more. It says, if a quadro comes in several years after the divorce is finalized, will OPM still honor the quadro? It says, we have an employee who started his federal career in 1979 and was married at the time, divorced in 1993, and a quadro dated 2001, stating the former spouse is entitled to annuity and survivor benefit earned up to the date of divorce under the CSRS. He is suggesting that he wants to retire this calendar year, but needs clarification on this.
We would honor it.
Yes. Since he's not retired, you can send it in now, and we will make a decision on whether or not that court order is acceptable. If that person had already retired and you just hadn't sent it in, and when you finally do send it in, we're not going to start paying until the second month after which we received it. But if that person is still working when that court order comes in, if it's acceptable for us to process, when that person does retire, you'll start receiving benefits when that person starts receiving their benefits.
It is extremely important that the provisions that are intended regarding awarding a survivor benefit both reflect the intent of the parties and conform rather to the laws and regulations. A lot of times we get people call in or write into our office and say what you've interpreted is not what we intended. This is not what I wanted. But we have to go by exactly what the order states. As we mentioned earlier, our office's role is simply ministerial. We don't do anything but interpret exactly what the order says. So the intent really should be really specific. And they can go to the table as many times as they need to, but while court orders can be changed before the retiree dies, in general, it needs to be known that after that person dies, then the order cannot, the order won't change, or we can't affect a change.
Basically, the apportionment part, the part that the former spouse is awarded of the monthly benefit of the annuitant, that can be changed as many times as they want, before retirement and after retirement. We get amended apportionment orders all the time that change the amount of the monthly benefit that the former spouse is awarded. But that survivor benefit, it cannot be changed after retirement. It cannot be changed after that annuitant dies. So anything that you're going to do to that survivor benefit, I don't know how many times you want to go back to court and hash out how much of a survivor benefit that former spouse is going to get. It has to be completed and done before that person retires, because after that person retires, there can be no more modification to the survivor benefit. And if that person dies and that survivor benefit is not hashed out, it can't be changed.
We have cited it slightly, very briefly before, but also, in addition to the apportionments, in addition to the survivor benefits, we also, in court-ordered benefits, process garnishments. And A garnishment is a legal process under state law for enforcing existing legal obligations. And a retirement can be garnished for alimony, which is also called spousal support, child support, or child abuse judgments enforcement. And the garnishment must conform to all the state laws, and then it has to be submitted to OPM, and it is subject to the limitations of Section 581, as we've stated before. We've talked about the former spouse eligibility under FEHB a little bit before, but let me just make this note that the former spouse is not eligible to retain coverage, under the employee's family enrollment, because as we've stated before, they are no longer a member of the family once they are divorced. Go on.
I was gonna say, you'd be surprised the amount of calls that we get from annuitants or people who were employees before they retired, who said that their HR office told them that it was okay to continue to keep their former spouse on their family plan because the divorce directed that, the divorce decree or the order dividing benefits directed that that person maintain health coverage for the former spouse. You have to go about it the proper legal way, and that's either through temporary continuation of coverage or eventually through spouse equity. But once you are divorced, you are no longer an eligible family member under FEHB rules, and therefore you can not keep your former spouse on your family health benefits plan. Children, yes. Former spouse, no.
Okay. Actually, the next couple of slides are repeats of some things that have come up earlier in our discussion regarding the handbook, temporary continuation of coverage, as well as conversion. If you ladies have anything to add, then we can jump in. But then, of course, the non-eligibility of the Fed-VIP programs, this next slide talks about how the fact that you cannot apply. A former spouse cannot apply as a qualified relative under the long-term care plan. However, a former spouse can continue coverage if they're already enrolled in the long-term care program. If they subsequently loses qualified relative status, such as being a party in a divorce, as long as the carrier continues to receive the premiums, they can continue. I think we have some more questions, or at least one more. Two. Okay. This question says, if a court order has both CSRS and FERS in the court order, but the employee is under CSRS, but in the benefit section, and what the former spouse would be paid only talks about FERS benefits and doesn't mention CSRS in that specific benefit section, would this court order still be valid? I'll repeat that. If the court order has both CSRS and FERS in the court order, but the employee is under CSRS, under one retirement system, but in the benefit section, and what the former spouse would be paid only talks about the other retirement system, or FERS in this case, and it doesn't mention CSRS at all, would this court order still be valid?
Fixed.
A lot of times when these court orders are done, sometimes the attorney will call us and ask what retirement system they're under. But if they're still working, we don't know. So we always tell them to either they could put both retirement systems on there. If it comes in and it meets all of our regulations, if it states CSRS and FERS, because they're not sure, then we can accept that order and still process it, because it's still talking about the retirement system of that employee. They may have been confused about which retirement system they're under, but they did expressly state that they were under either one of those retirement systems. So I would still process it.
Okay, and the second question is, if an employee retires and does not submit a copy of the court order to your office, if they don't submit it with the retirement application, does this delay the retiree's annuity?
The only thing that we look at when that person retires, if the former spouse has not submitted an application, only thing that we're going to do is look at the court order for survivor determination to see whether or not that former spouse was awarded a survivor benefit, so that retiree's benefit can be properly reduced for that former spouse's survivor benefit. But we will not hold the case up for an apportionment to be paid if no application has been received.
Thank you. That's all of those questions. Shania, would you talk a little bit about life insurance for us?
Sure. Do we have any more questions from the audience, though, before we move on? Okay, assignment of life insurance. This is a benefit of employment and retirement that allows employees to assign their life insurance coverage to another person, a firm, or a trust. Once this person designates the firm, the trust, the other person assigns the life insurance to them, that person, the employee or retiree no longer controls the life insurance. It's like you're handing over your life insurance to somebody else who can then make decisions about that policy. That other person can then designate beneficiaries, divide the policy however they see fit. And once the employee or retiree does this, you can't take that decision back. The decision is irrevocable, and you can do it with your basic, your option A, and your option B insurance. The only one you can't do it with is option C, which is the family coverage. But some people do it though, or some people do it because of the divorce. They assign another person the control, basically, of their life insurance policy. A lot of times when the court order comes through OPM, it will require that employee or retiree assign their life insurance over to the former spouse or one of the children of the marriage. The retiree or the employee has to complete the proper form, which is RI 76-10, the assignment of federal employees group life insurance. But that is not handled by the court-ordered benefits section. If a former spouse is seeking to know whether or not that has been processed or the employee or retiree has complied, if the person is still employed, they would have to contact the employing agency to see if the person has complied with assigning the life insurance. And if that person is retired, they will contact the Retirement Operations Center in Boyers to find out whether the person has complied with the assignment of the life insurance. But it wouldn't be court-ordered benefits. We have no way to enforce it. The court order over the order of precedence requires that the provision of a court decree of divorce, annulment, or legal separation, or the terms of the court order or court-approved property settlement agreement be followed instead of the statutory order of precedence designated by FECLI. So I think FECLI has a specific order of precedence that they will pay if a person doesn't have a designated beneficiary on file. A court order pertaining to that employee or annuitant can trump FECLI's precedence for paying out the life insurance benefits. Sometimes we get court orders and that prohibit the insured individual from changing the designation of beneficiary. And we see that a lot in post-retirement divorces, where the former spouse was named designation of the beneficiary of the life insurance at the time of retirement, and then the court order will come in that divides the benefit and will say that retiree is prohibited from changing the person named as the beneficiary. The only way that they can go back and change it is if they get a court order that comes in and tells us basically that it's okay for that annuitant to change their life insurance beneficiary. In order for us to administer anything regarding FECLI, It's the same as with anything regarding the annuity payments to the former spouse. Everything has to be certified, and we should have it before that person dies. For active employees, again, all of that information, the court order and everything would go to the employing agency, and for annuitants, it would come to OPM. For compensation as well, I'm assuming it's OWCP. The first 12 months of non-pay status, the information goes to the employing agency. After 12 months in a non-pay status, the information is sent to OPM.
Could Shania, or Denise, could you all talk a little bit about the importance of receiving certified copies, and this apart from the life insurance, but maybe inclusive of that, the importance of receiving court-certified copies of documents in court order benefits?
Well, it's pretty simple. OPM cannot pay any benefits to the former spouse unless we have certified copies of the divorce decree, any court order dividing the benefit, and copies of the marital settlement agreement. If we don't have certified copies, we cannot pay out benefits. The only thing that we can do with non-certified copies is make a determination regarding whether or not that former spouse is awarded a survivor benefit. But any apportionment money that is due, or any portion of the monthly payment to the annuitant that is due to the former spouse, will not and cannot be paid unless we receive certified copies along with the application for benefits.
All right. Designations of beneficiary. A divorce does not affect a designation of beneficiary that was filed at some earlier time. An employee or retiree who has designated a now former spouse to receive the insurance or the retirement lump sum benefits must file a new designation of beneficiary in order for any benefits that become payable to go to someone else. That's pretty self-explanatory. There are citations that to go into more detail. If you will, you'll find those in the CFR. Actually, the forms that are used are noted here. They're pretty much on OPM's website, and I'm sure all of you have them in your offices. The proper forms for the designation of beneficiaries are listed there.
Okay, so what are the agencies responsible for? Pretty much the employing agency is the go-to source for information while that person is still employed. Like I said earlier, OPM doesn't receive any records pertaining to that person's retirement until that person separates from employment and makes application for a retirement benefit. The employing agency is going to handle all the health benefits enrollments for former spouses. They're going to take the premiums. They're going to take any assignment of life insurance forms. They're going to take any designation of beneficiary forms. And for the health benefits, just so you can pass this information on, the premiums are at full cost for the former spouse. They have to pay both the government share and the employee share. They don't get the same break that the employee gets with respect to the health benefits premiums. Sometimes agencies are subpoenaed, just like OPM is sometimes subpoenaed for information that's inside the employee's OPF. And the agency can provide a response to a subpoena signed by a judge or a release that's been signed by the employee. You can tell them what retirement system the person is covered under, how much money you withheld in contributions, and you can also provide an annuity estimate if subpoenaed by the court. Agencies should only be preparing benefit estimates, which I think you guys pretty much already know. And you can also let them know how much of a benefit that employee has earned up to the current date. You shouldn't be providing speculation about how to draft a court order at all. Your stance should pretty much be the same stance as OPM. If you want to know how to draft a court order, refer to the regulations, which would be Code of Federal Regulations, Part 838, or refer to the attorney handbook, which is posted on OPM's website. You should not be providing any guidance at all the OPM or the agency on how to draft a court order that's acceptable for processing. And again, like Trevor said, the role of OPM is strictly ministerial. We make a decision as to whether or not the court order that you submitted meets the regulations that are provided in Part 838. We will inform the former spouse and the annuitant if the court order is acceptable for processing. We'll tell you when the benefits become effective, if known, and that's usually in the case of retiree orders. And we'll tell you what we believe your court order tells us to do with your retirement benefit as far as the calculation is concerned. When we get ready to apply the benefit, we're going to inform the employee, the retiree, the attorneys who submitted court orders. We'll let them know if the court order is acceptable, when the payments will commence, the amount of the payments, and what formula we use to come up with the amount of the monthly payment. If there's any party, whether it's the former spouse or the employee or retiree, that believes the court order that was submitted is invalid, or they have to go back to the state court to prove the validity or invalidity of the court order. It's not up to OPM to determine whether or not one court order submitted by one party is valid and the other one is not. OPM is going to process the court orders in the order that they are received. We're not going to make a determination as to whether or not this person's court order is valid and the former spouse's court order is not valid. That is something that must be hashed out in the state court. And again, the note says at the bottom, if the order is not acceptable, the parties have to return to the state court to make the modifications. OPM's not going to make any modifications to your court order, and we're not going to interpret any intentions of the court order. The court order has to be clear in what it wants OPM to do with that retiree's annuity.
And so, just, in summary, the orders have to be clear. They just have to be clear, and OPM will make the payments, will authorize the payments. And that's, I guess that's a good word to note, because a lot of times our customers, the former spouses or even the retirees, will contact us thinking that we make the payments. We authorize the payments. The payments come from the U.S. Treasury, but we do authorize them in our office. So a lot of times in our explanations, I will have to let them know that our office authorizes the payments, then it is transferred to the United States Treasury, and they will pay it out. But we will authorize those payments in accordance to acceptable orders that fall within the guidelines of the laws and regulations. Now that's what OPM is responsible for, but also the affected parties, they have some responsibility as well. Probably the most, to summarize all of this particular slide, the most important thing for the parties that are involved is to keep OPM informed. If there are new orders that come in, keep us informed. Submit the new orders. If there are changes in address, keep us informed. As we mentioned a little earlier, we're putting in place some things where we can find them, but it's much easier if the parties involved would just let us know. I've moved. I've changed my address. So they do need to submit anything new, any changes to us. And as Shania has already said, we process them in the order that they are received. And they should certainly do all of this as soon as possible. Yes?
And one thing that people sometimes forget, and they say that, oh, I'll just do it. When it's time for me to retire, I put it in my retirement package. If your former spouse passes away before you retire, and you've already submitted a court order to OPM that awards that person a benefit, please submit the death certificate to OPM so we can let you know whether or not a benefit is still payable or not payable. Because, I mean, as most of you know, when a person retires and it shows up in their file that they have a court order on file with OPM, their interim pay is reduced drastically. So if there's no benefit payable because your former spouse has passed away before you retired, you might be able to circumvent that whole process of having your case have to come through court order for a determination if you submit the death certificate ahead of time.
You know, another thing that just occurred to me, a lot of times we will get calls when the former spouse passes away, and they've been receiving an apportionment, a monthly apportionment, then they pass away, and the annuitant expects us to immediately stop that apportionment. But we cannot do that. And Denise, can you speak to why we don't just immediately just drop the apportionment?
We have to look at the court order again to make sure that the court order doesn't state that it goes to any surviving children or to the estate. Because if it goes to either one of those parties, that allotment is still going to come out until we receive the information from the parties. If they decide that the children don't want it or the estate, they have to get an amended order in order for us to release that money back to the retiree. If it doesn't state anything about going to surviving children or the estate, that's when OPM will release that money back to the retiree. But we can't do it until we revisit that court order to make sure that it doesn't state that in the order.
Absolutely.
Any more question?
Is there a certain amount of time of how long you keep the court orders on file, or are they kept on file up in the rock?
When we receive court orders for active employees, after we approve the order, we normally keep it in our office for 30 days, just in case any questions arise. After that, we send that court order to our office in Boyers, Pennsylvania, so that it could be filed, and when that person retires, that court order is associated with the retirement file. If it's a retiree order, we normally keep it in our office for 2 years for questions or anything, and then after those 2 years, we purge those files to our office in Boyers, Pennsylvania, so that it can be associated with the retirement file.
Okay. And regarding applications?
Okay, we talked about applications earlier, but the former spouse generally must apply in writing to be eligible for a portion of the employee's annuity. There really is no special form that's required. And if the former spouse can't do it themselves, or there's some kind of an impairment, or they're incompetent, a representative can apply on his or her behalf to begin receiving the benefit from the retiree. Unless the court order is already on file at OPM, the letter for application must be accompanied by certified documents, which we talked about before, because we can't begin paying any apportionment benefits until we receive certified copies of the divorce decree, any order dividing the retirement benefit, and any settlement agreements that were associated with the divorce. Also included in this non-formal application must be a statement from the former spouse or his or her representative that the order is currently in force, it has not been amended or superseded or set aside. And that statement needs to be in there specifically, and that's also in the regulations. This is extremely important. If an annuitant or former spouse is sending a court order to OPM to be processed or to be pre-approved if the person is still employed, we must have the full name of the employee or the retiree, the full name of the former spouse, the social security numbers for both parties, the claim number if the person is a retiree, and the date of birth. And we also need current mailing addresses for both the annuitant or employee and the former spouse. If we don't have that, it gets pretty hard to locate people, and we need the social security numbers to store the correct information in our system as to what court order is associated with what party. So that's extraordinarily important. If a document or documents come into court order benefits and it doesn't have all the identifying information that we require, most of our customer service specialists have been trained to send those documents back, and they won't be processed until that order is received. Until that information is received.
It might be worthy of noting that we have quite a number of former spouses out there that we are not able to pay, they have submitted orders in years past sometimes many years past, and we're taking the money, we're withholding the money from the retiree, but we are not able to pay the former spouse because we don't have sufficient information. And so that money's just hanging out there, waiting for someone to contact us and apply completely.
A lot of times, if the former spouse has given us a phone number and the address may be from 1998, 2001, we will try that phone number to call to see if this is still a current mailing address for them. But a lot of times, if it's older than 2 years, we'll normally send out a letter to that former spouse at the address that we currently have, letting them know that their payments are going to start, but we just need to verify that address. And we ask them to send in that information to us so that we can start their payments.
You have another question?
Yes, we do have a couple of more questions. First of all, what if OPM has not received a copy of the Quadro prior to retirement and only receives a copy of the retirement package and the Quadro is not acceptable for processing?
So it's not a pre-approval. The Quadro was submitted at the time of retirement with the package, with the retirement package, but it's not acceptable for processing?
Yes.
They will be notified that it's not acceptable for processing.
Correct.
Okay. If a court order acceptable for processing or a COAP was not sent in, if the employee retires and there is a court order that says the former spouse gets a survivor annuity and it's a pro rata share, how does OPM process the amount that reduces the pension for the cost of the survivor annuity?
When the former spouse applies for her court-awarded portion, and when we set that former spouse up, we will start deducting that survivor cost from the former spouse if she is to pay the survivor cost. But there is no way that we can deduct the survivor cost from a former spouse if that former spouse has not applied. We can only do it once that former spouse has applied and that former spouse starts receiving payments.
If that court order is acceptable for processing, that awards a former spouse a survivor benefit, if that court order would have been acceptable for processing prior to that person's retirement, but we didn't get it until sometime after they retire, if the court order is silent, then the annuitant bears the cost for the survivor benefit, and they will determine how much your annuity should have been reduced at the time your annuity commenced, and they will bill you retroactively for that survivor reduction cost. Okay, so back to applications. If you have a court order that says that your former spouse's benefit terminates upon remarriage, we can't issue a payment without a statement from the former spouse that a remarriage has not occurred. We have to verify whether or not that former spouse is remarried before we release the payment, but only if the court order says that the benefits would terminate in the event that the former spouse was remarried. And that's pretty much it about applications, except where you need to send them to. All documents related to the divorce, including any orders that divide the benefit, marital settlement agreements, the certified divorce decree, they should all be sent to us at the U.S. Office of Personnel Management, Retirement Services. P.O. Box 17 is specific to court order, and that's Washington, D.C. 20044-0017. And if you have any information regarding court-ordered benefits, whether you're following up or you want to know where you need to send it, et cetera, you can call the Retirement Operations Center at 888-767-6738.
And there are customer service specialists that are available from 7:30 a.m. to 7:45 p.m., and you may leave a message. If you're not able to reach someone, you may leave a message at that phone number that Shania just gave you. You can also email us at retire@opm.gov, or you can reach us on the internet at www.opm/retire. We thank you a lot for your time, and hopefully this has been very informative for you. And if you have any further questions, feel free to contact us in any of those ways that we have mentioned. Thanks a lot.
Thank you.
Thank you.